Thank you. Yes.
Daily list for motion, item 1.
This is a contempt application.
Yes, my lord.
I think it has come up for the first time.
Yes, my lord.
What is the contempt about?
This contempt is filed by the petitioners who are 7 in numbers. Under Rule 9 of Contempt of Court, Guwahati High Court Rules 1997, read with Section 12 of the Contempt of Court Act 1971, against the respondents for their willful and deliberate defiance of the direction passed by the Dishonorable High Court White Order dated 21/11/2024 in WPC number 103 of 2023, whereby a direction was made to the respondent authorities to refund the 10% cess deduction.
Cess amount.
Yes, my lord. And secondly,
I think there are so many judgments which says this cess cannot be deducted from the compensation, right?
yes, my lord.
Even Supreme Court judgments are there.
Yes, my lord. And secondly, my lord, the respondents were directed to reassess the interest payable under Section 80 of Act of 2013. And thirdly, the state respondents are directed to establish land acquisition, rehabilitation, settlement authority in terms of Chapter 8 of the Act of 2013. Amongst these 3 directions, my lord, the first one is already complied.
You will refund it.
Yes, my lord.
Okay.
However, the 2 other directions are still not complied. And hence this petition, my lord.
Okay. Today I'll issue notice to the
Yes, my lord.
respondents. Okay. This is the contempt application filed for willful and deliberate defiance of the direction passed by this honorable court, by order dated
21/11.
yes 21/11/2024 in writ petition number 103/2023, by which 3 directions were given by the Honorable Single Judge, and the said 3 directions are: A, within bracket, the amount deducted from the compensation, the amount of cess deducted from the compensation to be received by the landowners were directed to be refunded to the said landowners within a period of 2 months. Then B, the district collector was directed to determine the date of taking over possession of the land within a period of 2 months. Shall determine the date of taking over possession of the land of the petitioners, by giving them opportunity of hearing within a period of 2 months, as well as upon determination, the collector was directed to assess the amount of interest payable to the petitioners and forward the same to the Union of India for its ultimate payment to the landowners within a period of 2 months. And C, the state respondents were directed to establish the Land Acquisition, Rehabilitation and Resettlement Authority and to make establish authority, and the said authority was directed to make a reference in terms of section 64 of the LA Act, right?
Yes, ma'am.
Of the LA Act. What did I say? And as well as the authority. In terms of those persons who has not accepted the award, and that all the applications should be considered in accordance with law. For violation of the aforesaid 3 directions, the contempt petition is filed. It is stated by Miss Dinari
Bilaram Nemi.
T. Arzu. No.
She's my senior.
Okay. Your name is here.
Yes, my lord. Bilaram Nemi.
B. Lalram Hemi.
Yes, ma'am.
Okay. Miss B. Lalram Hemi, appearing in the instant contempt case, has however stated at the bar that as far as the first direction is concerned, the same is complied with. The same is complied with by the authority concerned. However, she stated that there are willful violation of the other 2 directions given by this honorable court. One second. Then see, issue notice returnable by 4 weeks. 4 weeks will do.
Yes, ma'am.
Petitioner to take steps for service of notice upon respondents. How many respondents?
6 respondents.
Take steps for upon respondents number 1 to 6. Wait, I'll just check up once. 1 to 6. Yes, 1 to 6 are of all autonomous district and okay, 1 to 6 by registered post with AD within a period of 4 days.
Yes, my lord.
Within a period of 4 days from today. List this matter after 4 weeks.
Yes, my lord.
List this matter after 4 weeks.
Obliged.
For admission, item number 2.
Zakir.
My lords.
Yes. Today I think it's for impleading.
My lords, the other matter is for impleading. This can be heard, my lords.
The other matter?
Yes, my lords. That is item
4.
4, I think.
In that implement application is to be.
Oh, otherwise 2 implement is done.
Done.
Okay.
Now let's
Let's see the last order of. Acha.
Objection is filed, but it may not be placed before the objection. We fight this.
So here, respondent number 2, you are appearing.
yes, let's objections have been filed, let's but let's my humble prayer is that let's I may be allowed to raise a preliminary objection with regard to the validity of this petition on account of a legal defect which goes to the root of the matter, namely the affidavit accompanying this petition is that of an advocate.
Your affidavit is not on record, I think, today.
My affidavit, we have filed it on 16th June 2025.
16 June means yesterday.
Yesterday it has not come
Yes,
on
ma'am.
record.
Yesterday.
It has not come on record.
It has not come, it is not in the record.
Actually, maybe, Lordship, that was subsequent to the file being forwarded to your Lordship, Chamba. Maybe.
I couldn't get you. What?
But what he wants to say is that
Maybe, yes.
maybe the files had been sent to your ladyship's office
Uh-huh,
and
uh-huh.
after that it has been
It was
filed.
little
So
late
it may
because
not
of
be a
the-
part of the file
It's
which
already
is,
there, my Lord.
So one thing we can do, let your affidavit be on record and let the matter come up tomorrow.
Tomorrow?
You are not from Mizoram, I suppose. You have come from outside.
I am from New Delhi,
Oh, acha.
so I have
Stay
traveled
back.
from. I
It's a
have,
beautiful place. Stay back tomorrow.
yes, let's
Yes.
tomorrow. It's all right, but let's if that affidavit. If your ladyship is kind enough to hear on the preliminary objection, maybe
Huh.
if my preliminary objection is sustained.
Orally, I can hear you, but affidavit
Yes.
is not there.
What I am saying is that that's the legal point I am raising.
Okay, okay.
Without incorporating it in that affidavit. Supposing my objection is sustained, then he will have to take recourse to filing a proper affidavit of the client.
Okay, okay. Now, let me see. What is your objection here?
Now kindly see the affidavit in this petition, which is at page
33.
33.
33.
33.
333.
What is this application attached to this? Oh, this is the application before the CJM.
No, my lords. This is 33.
33 is an affidavit which he has annexed in the application before the CJM,
CJM.
not before the High Court.
High Court affidavit is.
In our copy,
Yes, it is at page 15.
1-5.
I stand corrected. The copy given to me.
Huh.
it is correct. 15 minutes.
Yes, 15 is the affidavit.
Yes, minutes.
Next to the High
Though the details are not filled up, it's a blank, but I can make out is
Acha.
that this is the affidavit of the lawyer. That I am one of the counsels of the accused petitioner of this case, and as such I am fully acquainted with the facts and circumstances of the case, and I am duly authorized by the accused petitioner to swear to this affidavit in support of the facts stated in the accompanying petition. And the authorization letter, if I am not wrong, is at page
57.
50, annexure 4, it is,
57.
yes. I undersigned, who is presently detained in the central jail in connection with the crime number so and so, do hereby authorize and appoint Shri Lal L. Ralte, son of so and so, to file a bail application for me and on my behalf, and do any other necessary steps, and also to give his signature for me on my behalf. And my humble submission relates this practice of the lawyers assuming the dual role has been deprecated by the Honorable Apex Court as early as in 2001. And there are many decisions of various Honorable High Courts which have deprecated the practice and said that such an affidavit would be invalid in the eyes of law, and such an action would amount to a misconduct on the part of the lawyer. So I have got the judgments which,
Let me see these judgments. Otherwise, that's a normal habit, like the
In my
petitioner
humble submission,
authorizes and then
the
your
things
lordships may
things
change.
go on unnoticed until they are pointed out. Section 30 of the Advocates Act specifically prohibit. In fact, only Honorable High Court of Delhi has used the expression that a person cannot wear two hats, that of a client as well as of a lawyer. The lawyer's profession is a noble profession, and the lawyer is an officer of the court, owes a duty to the court. He cannot do it. The first judgment is that of Honorable Apex Court, in which there is a specific reference to this, and the Honorable Apex Court has.
in the authorization letter, of course, he did not write he is a lawyer. He simply appoints Lalman Ralte
Yes.
to file a petition.
Yes, that is another fatal omission, that the identity itself is not disclosed in this authorization, and the authorization is by virtue of the fact which is disclosed in the affidavit which is at page 15.
Yes. I am one of the counsels.
Give all the judgments.
Okay. The first one is 2001.
Yes, in fact, Vinay Kumar,
Vinay Kumar.
My lords, if I could have the citation.
yes, I'll give the
Please serve him
copies.
the copies.
There is a reference only in this This was not a public interest litigation. Para 3 of that judgment refers to this with reference to section 30 of the Advocates Act. I'll read para 3. In the instant case, the petitioner had not filed the petition in public interest and did not disclose the circumstances which prevented the affected persons from approaching the court. In the discharge of his professional obligations, the petitioner advocate is not obliged to file the petition on behalf of his clients. No circumstance was mentioned in the petition which allegedly incapacitated the affected person from filing the petition. Section 30 of the Advocates Act only entitles an advocate to practice the profession of law and not to substitute himself for his client. The filing of the petition in his own name being a part of the professional obligation of the advocates, the High Court was justified in dismissing the writ petition, holding that the petitioner had no locus standi. This has been further elaborated upon by judgment of the Honorable High Court of Allahabad.
But here, of course, there is a rider, you can see.
Yes.
In the advocate, no circumstance was mentioned in the petition which allegedly incapacitated the affected persons.
Correct.
Now, here is a case where the accused is in jail.
Correct. Then
And
he
then-
could have appointed somebody else. I am elaborating upon further. The
Not
lawyer can't
advocates.
assume that role. The lawyer can't assume the role. He can't be simultaneously a perukar as well as a lawyer. The Honorable High Court of Allahabad in 2017, Ladyship has the judgment.
Yes, I have it.
Para 3 onwards. In fact, I
This
can read
is,
from.
Baljit Singh.
Yes, Baljit Singh. Para 3. The learned counsel for the respondent submit that Shri Rohit Kumar Tyagi was in fact the counsel for the appellant before the lower appellate court, and therefore, as counsel, he cannot be the perukar of his client and file an affidavit to the stay application in support of the present second appeal, and this act of his amounts to professional misconduct. On the preliminary objection so raised by the learned counsel for the respondent, the court, by its order dated so and so, directed Shri Tyagi to be present in the court on 16/5/2017 and file his affidavit. Shri Tyagi appeared before the court on so and also filed an affidavit. In para of the affidavit, he has stated that he is the family friend of the appellant and is doing parvey of the case and is well versed and acquainted with the facts and circumstances deposed to in the affidavit. However, the preliminary objection and the allegation of the learned counsel for the respondent that Shri Rohit Kumar Tyagi was the counsel of the appellant before the lower appellate court and therefore he could not have filed the affidavit in support of the present second appeal as a family friend has not been denied in the affidavit filed by Shri Rohit Kumar Tyagi. In the paragraph of the affidavit, the deponent, Shri Rohit Kumar Tyagi, submits an unconditional apology for the alleged misconduct as it was out of naivety and that he did not commit the alleged misconduct intentionally. Paragraph 3 of the affidavit reasoned. Ladyship may skip para 6 up to para 6 and then para 7. In my opinion, the contention of Shri Rohit Kumar Tyagi, advocate, is thoroughly misconceived. Counsel who appears through wakalatnama on behalf of his client cannot step into the shoes of the client. His identity must remain distinct from that of his client. It is one thing for an advocate to file personal affidavit in his client's case to explain the delay in filing the case if attributed to him, that is to the lawyer. But it is quite another thing for the advocate to file petition or appeal or proceeding on affidavit swearing to the facts which concern only his client, and more so when the advocate has appeared for the said client in earlier proceedings in his capacity as the client's advocate and not as his witness. The Supreme Court in Vinay Kumar, that has been referred, then Ladyship has seen Vinay Kumar's. Then para 8, the Supreme Court has referred to the provisions of section 30 of the Advocates Act 1961 and has held that the said section really entitles an advocate to practice the profession of law and not to substitute himself for his client. The filing of the writ petition in his own name was not part of the professional obligation of the advocate, and the High Court was therefore justified in dismissing the writ petition, holding that the petitioner had no locus standi. Section 30 of the Advocates Act provides that every advocate whose name is entered in the state roll be entitled as of right to practice throughout the territory to which the Act applies. Thus, an advocate gets his right to practice in court only under Section 30 of the Act. Practice in itself means to appear on behalf of his client before court or tribunal in the best interest of his client. Practice, however, certainly does not give liberty to an advocate to identify himself with his client and step into the shoes of his client so far as the rights of his clients are concerned. Section 30 reads as under. Then section 30 is quoted, and thereafter conclusion in para 10. I am therefore of the view that prima facie the said advocate Shri Tyagi is guilty of professional misconduct and identify himself with the client and filing an affidavit in support of the present appeal. But considering that he himself has expressed that he had acted under naivety and has submitted an unconditional apology, do not propose to refer the matter to the disciplinary committee. Next judgment is of Honorable High Court of Odisha, wherein Panigrahi's judgment. The Honorable Court has extensively referred to the other decisions of various Honorable Courts.
In this Allahabad case, which paragraph you had relied on first?
Para 7 and 8, start para 3, para 7 and para 8.
3, 7 and 8.
Allahabad High Court is para 3.
Then, the other one?
Allahabad High Court. Para 3, para 7, para 8. Then Odisha High Court. Kindly come to para 6 onwards. Recently, it is noticed that there has been a growing, this concerns a case where the advocate's clerk files an affidavit. It is noticed that there has been a growing trend of advocate's clerk signing affidavit for applications, petitions, counter affidavits imperviously and oblivious of the contents therein. A wakalatnama to represent a party in court is held by an advocate and the brief is entrusted to the advocate. The advocate-client relationship is quite clearly accepted as a fiduciary relationship and the communication is privileged and confidential. It is strictly between the client and the advocate. Neither the brief nor is the permission to represent a party to be shared by the advocate with his clerk. An advocate's clerk signing an affidavit instead of party himself or a person designated authorized by the party or the advocate holding the wakalatnama is unacceptable. And as such, attempts to subvert the law is impermissible. An advocate's clerk as defined so and so. Then kindly come to the bottom. The courts have always come down heavily on the practice by initiating contempt proceedings where they have discovered that an advocate's clerk has falsely signed an affidavit. The most recent instance of the same being the order passed by a coordinated bench of this court, wherein a show cause attempt notice was served on so and so. Then kindly come to para 7 where the reference is to the provisions of CPC regarding affidavit, order 19 of CPC 1908. Affidavits shall be confined to such facts as the deponent is able on his own knowledge to prove, except on interlocutory applications on which statements of his belief may be admitted, provided the grounds thereof are stated. Then the Odisha High Court rules have been extracted.
Which rules? Which page?
Rules, para 7, the rules of, specific rules of Odisha High Court.
Chapter 6 of the
Yes,
general rules.
that is chapter 6 of the general rules, which also says that the facts stated in the petition have to be of the personal knowledge of the client. Then para 8, the importance of affidavits strictly conforming to the requirements laid down in order 19 rule 3 of the CPC has been discussed as far back as in 2010 in Padmavati Dasi versus Rasik Lal Dhar, wherein the Honorable High Court of Calcutta held as under. We desire to impress on those who propose to rely on affidavits that in future the provisions of order 19 rule 3 must be strictly observed and every affidavit should clearly express how much is a statement of the deponent's knowledge and how much is a statement of his belief, and the grounds of belief must be stated with sufficient particularity to enable the courts to judge whether it should be sage to act on the deponent's belief. The Honorable Supreme Court of India in State of Bombay versus Purushottam Jagnayak, wherein a constitution bench, while considering the importance of the verification of an affidavit, among others, held as under. We wish, however, to observe that the verification of the affidavits produced here is defective. The body of the affidavit discloses that certain matters were known to the secretary who made the affidavit personally. The verification, however, states that everything was true to the best of his information and belief. We point this out as slipshod verifications of this type might well, in a given case, lead to a rejection of the affidavit. Verification should invariably be modeled
And this is
on the
okay,
lines
this
of.
is on
This
verification.
is slightly on a different aspect, but then para 10. An affidavit is an accepted mode of placing evidence before the court. A party uses an affidavit to prove a fact or facts before the court. Perforce, such an affidavit should always be in accordance with the prescribed rules. The purpose underlying the rules is to enable the court to find out as to whether it would be safe to act on such evidence and to enable the court to know as to what facts are based on in the affidavit on the basis of personal knowledge, information, and belief. This is relevant for the purpose of appreciating the evidence placed before the court in the form of affidavit in the light of the right perspective. It is for this very reason that a party swearing an affidavit must disclose as to what facts are true to his personal knowledge, information, or belief. If the statement of fact is based on information, such source of information must be disclosed in the affidavit. An affidavit which does not comply with these provisions has no probative value and it is liable to be rejected. An advocate's clerk who has no personal knowledge of the facts of the case nor is independently empowered to swear such an affidavit is not permitted in law to file a token and mechanical affidavit. When the rules clearly lay out form, content, and degree of knowledge required to be included in an affidavit to ensure the reliability and veracity of the same, any affidavit which is not in strict consonance with the same has to be discarded. This is applicable equally to the advocate also. The
But
personal
then-
knowledge of the
yes.
facts of the case can't be taken over.
Here it said advocate's clerk also,
Yes,
will
yes.
have no personal knowledge.
Correct.
But the advocate himself will definitely have personal knowledge. That
In
is
my humble
different.
submission, Blitz, the personal knowledge of the facts of the case is different from the knowledge based on the basis of the facts disclosed in the case file. The advocate would acquire the knowledge on the basis of the file. It can't be substituted with the personal knowledge in the knowledge of the client. That is why the sanctity. The CPC requires the affidavits to be sworn by the parties. In fact, in the CPC, there is no provision which entitles the affidavit to be filed by another person instead of a party. Here, the authorization also does not say, I am not going to the form of the affidavit, the adherence to the provisions of law that which part is personal to his knowledge, which part on the basis of the perusal of the file, etc., etc. I am saying the capacity or the standing of the advocate to file an affidavit on behalf of the client is not valid in the eyes of law. The decision of the Honorable High Court of Delhi may also be perused, whereby Anil Kumar. Acha, this is marked. Kindly see this. This I have marked this, no?
I think the person who is authorized has not filed the wakalatnama. I think his name is not there on record.
He says in the affidavit, I am one of the counsels. I am
But
one of the
then,
counsels.
In the cause list, his name is not shown.
Not shown, my lords.
Maybe, but the contents of the affidavit speak for themselves. As an advocate, even if he has not filed the wakalat, the Advocates Act section 30 referenced by the Honorable Apex Court. Kindly see this judgment what has been with regard to the authorization to the it amounts to doing some other activity apart from professional activity of an advocate. If you start pursuing the cases, following the cases as parokas, as authorized persons, that also is not strictly within the purview of section 30's embargo. Advocate's activity is defined that you have to act
Just
as a lawyer.
Let me see section 30 once.
Yes. Section 30 is
It was
quoted.
it was
Section
quoted
30 is
there.
quoted, yes.
But then still,
Section 30 is quoted in the judgment of Allahabad High Court,
yes, it's
para
quoted,
9.
But I'm seeing from the Act 30.
Yes.
Yes.
Unless there is some
Right of
discrepancy,
advocates
and
to
it-
practice.
Subject to the provisions of this Act, every advocate whose name is entered in the state roll shall be entitled as of right to practice throughout the territories to which this Act extends, in all courts, including the Supreme Court, before any tribunal or person legally authorized to take evidence, and before any other authority or person before whom such advocate is, by or under any law, for the time being in force, entitled to practice. Now, para 9, the interpretation of this provision is in para 9 above this extract.
In Delhi High Court judgment,
No, in this very judgment,
Allahabad.
Allahabad High Court. Thus, an advocate gets his right to practice in
Which paragraph you are reading?
para 9 above this extract.
No, I saw it from the Advocates Act, so.
Okay, in the judgment paragraph 9, Allahabad High Court judgment.
Yes. Yes, paragraph 9 is a long one.
Yes,
Which one?
para 9.
The last part of paragraph?
Last part, para 10 and 11 is the section, para 9 is last but one page. Section 30 of the Advocates Act provides that every advocate whose name is entered in the state roll shall be entitled as of right to practice.
1 minute, I'm not getting it. Oh, I'm taking Odisha.
This is, it's 2017 SCC online.
No, I'm sorry, I took Odisha judgment. Okay, 9, yes.
Yes.
Section 30,
Of the Advocates Act 1961 provides that every advocate whose name is entered in the state roll shall be entitled as of right to practice throughout the territory to which the act apply. Thus, an advocate gets his right to practice in court only under section 30 of the act. Practice in itself means to appear on behalf of his client before court or tribunal in the best interest of his client. Practice, however, certainly does not give liberty to an advocate to identify himself with his client and step into the shoes of his client so far as the rights of the clients are concerned.
My lords, I think this paragraph, my lords, makes it clear. Today, we are not stepping into the shoes of the petitioner, my lords.
let him finish, then you can say. Yes, then?
Yes, this means that they are identifying them. The advocate cannot identify himself with the client by acting as an authorized person. Now kindly come to Delhi High Court, where the authorization also is discussed.
Acha. Paragraph?
Para 6. The question raised in these petitions was whether Mr. So-and-so, who was acting as the power of attorney holder of the plaintiff and had verified the plaint on behalf of the said plaintiff, could appear also as a counsel in the matter. Mr. Sahani submitted that he would withdraw his wakalatnama and continue as the power of attorney holder and would no longer act as a counsel for the plaintiff. He again assured that the court he would withdraw his wakalatnama in the trial court and he would no longer act as a counsel for the plaintiff in the matter. He submits that he shall take steps within 2 weeks for substitution of the wakalatnama by a new counsel. It is made clear that the practice of advocates acting as power of attorney holders of their clients as also advocates in the matter is contrary to the provisions of the Advocates Act 1961. Any advocate who is engaged by a client would have to play only one role, that of the advocate in the proceedings, and cannot act as a power of attorney holder and verify pleadings and file applications or any other documents or give evidence on behalf of his client. This aspect has to be scrupulously ensured by all the trial courts. This legal position has been settled by various decisions. In Baker Oil Tools versus Baker Hughes, Delhi High Court held. Thus, as is manifest from the said rule, it would be a professional misconduct if a lawyer were to don 2 hats at the same time. However, not only that, the partnership firms have a hurdle for acting in the said two capacities even under the Partnership Act, as every partner in a partnership firm is an agent of another. This was because it was a partnership firm. So even that is not protected, may not be strictly relevant for this case. Then para 8, only to save time of this honorable court. Kindly see on the next page, some lines, last word of this paragraph. However, it cannot be forgotten by anyone who has ever been graced with the honor of wearing the robe.
However, since in the present case, what are you reading?
No, yeah, let's, para 7, last line at that page, last word at that page, starting from there.
Okay.
However, however, it cannot be forgotten by any who has ever been graced with the honor of wearing the robe, that lawyer is first an officer of the court, and his prime duty is to assist the court in the administration of justice. The rules of the conduct, as per the Bar Council of India rules, may act as a guardian angel for ensuring the moral conduct of the lawyers, but the legacy of the traditions of the bar cannot be bedaubed by a few of the lucre of commercial gains. A lawyer cannot forget that this is called a noble profession, not only because by virtue of this he enjoys an aristocratic position in the society, but also because it obligates him to be worthy of the confidence of the community in him as a vehicle of achieving justice. The rules of conduct of his profession, with its ever-expanding horizons, are although governed by the Bar Council of India rules, but more by rich traditions of the bar and by the canons of conscience of the members of the calling of justice, or being the Samaritans of the society. Thus, the foreign companies and firms must respect the laws of this land, and the solicitors and law firms are equally not expected to discharge their duties as clients for these foreign companies' firms. Law is not a trade and briefs no merchandise, and so the avarice of the commercial gain should not malign this profession. Hence, there can be no divergent view on the legal proposition that an advocate cannot act in dual capacity, that of a constituted attorney and an advocate. The plaintiff is a resident of so-and-so. He has verified the plaint and all pleadings on behalf of the plaintiff. He is also appearing the counsel so-and-so. So, in my humble submission, reading the first line of the affidavit that he is one of the counsels for the petitioner. In my humble submission, if this goes to the root of the matter, and it's not very difficult to have the affidavits prepared and get them signed by in the jail also. That is not an incapacity. In and out, his relations, his family, friends, anybody can swear to the affidavit in support of the petition, provided the conditions of the rule of CPC Order 13 is fulfilled, that he has to swear to the facts on the basis of personal knowledge or on the basis of him having been briefed by the client himself, by the petitioner himself.
But whether here the lawyer is stepping into the shoes one, and whether he is having two roles. Because now he said, I am one of the counsel of petitioner, but the fact remains he has not signed the wakalatnama.
In my humble submission,
And
that would be an hyper-technical aspect. The moment he says that he is one of the advocate, in fact, the Delhi High Court, he was the lawyer before the trial court. He was not the lawyer before the High Court at all.
He is attorney holder as well as he is.
Yes. Yes.
As well as he was.
Here, the authority is given by the authorization letter, which is akin to an attorney.
Yes, authorization letter 56.
Yes, at page 55.
57. Oh no.
Yes.
In connection with so
Do hereby authorize and appoint.
Lalman Raute, here of course he does not write, he is a counsel, son of so-and-so, resident of so-and-so, to file an affidavit, applications on my behalf, any
Let's
other
kindly
steps.
consider the nobility of the profession itself.
Lao
Nonetheless,
Mao,
he is a lawyer, and he himself says in the affidavit before this honorable court that he is one of the counsels. Even if he is junior in the council whose wakalatnama is there. In my humble submission, it would be appropriate to follow the standards, rather emulate the standards which have been laid down by the honorable courts with regard to the role of the professional lawyers, maintaining the sanctity of the profession, the majesty of the profession, the dignity of the court proceedings. Let them do it.
Mr. Jordan, you can do one thing, look into the matter,
Yes,
right, some more decisions on this point,
yes.
as to what extent it can be done.
Yes. I'll take instruction.
Let him go into the matter, then
Lordship.
we'll decide,
Lordship.
whenever he wants.
After a week or two. In fact, item number 4, unfortunately, the affidavit is of the lawyer himself. And the power of attorney also is given.
My lords.
Item number 4 also
Item 4 is mine, my lords. That
similar
I-
situation.
Acha.
Uh,
It is your affidavit.
Correct. correct.
Yes.
My lords, let me take
So
instructions.
let him go
Thursday, my
into
lords, the other matters are coming up. If it can be listed on that day.
Yes.
too many cases. In fact, these two cases have been segregated by lordships
Yes.
to be held
In our
because
own-
here the
yeah,
issue
only-
involved is different. Therefore,
Because I segregated because the issue is little different here. He wanted to
Correct,
reduce
correct.
the bond. And you know that Supreme Court has come time and again that excessive bond is
Lordship
bad.
is right.
It's almost like not giving bail.
ladyship is right.
So one
Therefore,
should not be inside for excessive.
what I am humbly submitting is, let those matters remain on 24th, let these matters be a week later, these two matters.
No, let it come up together.
Very well, Mills. I leave it to my
Right.
lords.
Together first decide on that, then
Very well.
cancellation of bail is also
Very
there.
well, Mills.
So, okay, then right. I heard Mr. Jordan so and so for the petitioner. And heard Mr. Your name is not.
I am Naresh Kaushik. I am
Naresh
designated
Kaushik.
by the Honorable Supreme Court.
Good to know. Mr. Naresh Kaushik appearing for the respondent number 2,
Two.
3.
Let's the 2.
Or 3 is who?
3 is Mahindra Financial Services.
So you can appear for both 2 and 3?
We are three.
Yes,
We are three.
we are 3 minutes, I am told.
Oh, there is only one respondent here.
Complainant is number 2, we are 3 minutes.
This is criminal
Number
petition.
1 is State of Missouri.
Huh?
Number 2 is the complainant. And number 3 is Mahindra.
In item
I think
number
you are not
2,
included. You
these
have filed your
corrections are not
objections
made or what?
You are not included.
No. Here, although the
In fact,
causations,
it appears that our 301 application has been allowed
Yes, Your Lordship.
and we
That
have been
was
heard,
way-
but in the memo parties, our name is not reflected here. So what he is directed to do in item 4 may be done here also.
item 4 also you are not there.
Yes, yes, leadership has directed him to implead us. The
Huh.
application is there. In
Yes.
this also, it may be done.
And this respondent number 2, Dr. R. Lalianga, he is the
He is not
informant.
represented. He is the complainant.
Complainant.
He is the complaint. You are appearing for him?
No, minutes. I am not appearing. He is not appearing. The notice may have to go to him also. The
Then,
notice may have to go to him also.
But then without, where is the petition which shows that you are a party?
Section 301.
301 application was there, my lord.
But then it's not in the
Earlier,
records?
order was there.
Asani, is it there?
There is a miscellaneous application filed earlier also, in which we filed petition for imprisonment, my lord.
My lords,
Or that
the-
perhaps is, I will be there, just see. But after that, you have to amend the cause title in the main
Correct,
petition.
correct.
So that perhaps is not done.
Yes, please.
Acha, this is a 301 application.
My lord.
Acha, there it is allowed.
Yes, sir. If I'm not mistaken, IA criminal,
Are allowed and disposal
10.
may file his written objection.
IA 10 years.
Okay.
The miscellaneous number, IA 10. Of 2024.
I is otherwise disposed of.
Earlier, yes. And we have already been writing the direction, if I'm not mistaken, also there in that IA for modification of, rectification
No,
of
in
the
view of this order in the IA, make necessary
necessary.
Cause title is to be amended.
amendment in the cause title. That I will give. Okay. So heard Mr. Naresh Kaushik, who has appeared in view of the order dated 18/3/2025, passed in IA Criminal
10.
IA Criminal 10 of 2025, filed in the Instant Criminal Petition 2 of 2025. Why this said order 18/3/2025, this court allowed the applicant in IA Criminal 10 of 2025 to assist the public prosecutor as per Section 313 of the CRPC oblique Section 338 of BNSS 2023. This court, by the said order, had allowed the applicant to represent the informant as well as to file written objections, if any. In view of the said directions, this court allows the applicant to make the necessary application for amendment of the cause title in the main criminal petition number 2 of 2025.
My lords, just one submission. Your lordships, this amendment may not be necessary because their application itself is for assisting the public prosecutor.
But then it remains in the IA. IA is disposed of. Nothing is reflected in the main petition.
Yes, yes.
As a consequence of allowing the OA, this correction, this
This
needs to
correction
be
will
carried
be
out.
made, then
My
it
lords.
becomes a part
So
of the
that
main.
the court is cognizant of the
Then
status.
he
Yes.
becomes a part of this
Ladyship
petition.
is right.
Okay, so allow him to amend the cause title of the criminal petition 2 of 2025, para. Mr. Naresh Kaushik submits before this honorable court counsel for the applicant who is this? He is the complainant, right? And what is your role here in
It's,
criminal petition
The
2?
facts of the case are this.
I know the facts.
The applicant is the main victim whose funds have been siphoned off.
Yes, that I know. But
The
then
complainant in this case happens to be one of the victims too. A loan is shown utilizing the amounts of Mahindra Finance, but fake documents are created whereby he is being shown as a loanee as a result whereof his obligation to repay to Mahindra Finance. That is how this transaction has been carried out. I am the greater victim, he is the lesser victim in the same situation.
he is what you said?
He is one of the purchasers of the car who has not availed of any loan facility actually, but has been shown as a loan taker from Mahindra Finance, whose money has been utilized off and siphoned off.
Mr. Naresh Kaushik submits before this honorable court that he represents the company, namely Mahindra and Mahindra
Financial Services Limited.
Financial Services Limited, from which company the informant is shown to have purchased a vehicle
Availing the loan facility.
availing the loan facilities from Mahindra,
Yes.
so and so, without there being any loan granted by the said company. It is stated that the informant, it is stated that the accused persons mentioned in the FIR by the informant had made fake loan certificates,
KYC documents,
KYC and other relevant
RTO
documents
documents,
and other fake documents on behalf of the informant, right?
Yes.
Informant to avail loan facilities from Mahindra so and so company. The said company being the victim, being the main victim, the counsel appearing for the same had filed the said 3001 application before his Honorable Court, which was allowed as stated above. In the instant petition, Mr. Naresh Kaushik takes a preliminary ground of challenge, stating thereby that the affidavit sworn in the instant criminal petition was by the counsel of the petitioner in the instant case. He had also placed the authorization letter which is annexed with the criminal petition, which also shows that the accused person has authorized the said counsel, namely Shri Lau Mau Ma Ralte, to file any petition, bail application or any other applications on his behalf, and to take necessary steps, and also to give his signature for the accused person and on his behalf. Mr. Naresh Kaushik submits that a counsel cannot file an affidavit on behalf of the accused persons, as the same would go against the professional ethics and the same is not contemplated under Section 30 of the Advocates Act. He has placed 4 judgments to substantiate his point. Number 1, Vinay Kumar versus State of UP, reported in 2001, Volume 4 SCC 734. Wherein the Honorable Supreme Court has observed in paragraph 3 thereof that in discharge of the professional obligation, the advocate is not obliged to file the writ petition on behalf of his clients. The Honorable Supreme Court has further held that having shown no circumstances which would incapacitate the affected person to file application, the petitioner advocate should not have filed the same. It was also held, Section 30 of the Advocates Act only entitles an advocate to practice the profession of law and not to substitute himself for his client. The second decision, right?
Allahabad High Court.
The Allahabad High Court. The second decision, Valjit Singh versus Pratap Singh, reported in 2017 SCC Online Allahabad 3489, wherein the Honorable High Court of Allahabad had observed that the advocate who files wakalatnama on behalf of his client cannot step into the shoes of the client. His identity must remain distinct from that of the client. Same thing is in paragraph 9, so it's okay.
After that, yes, Tarasim.
Then C.
Then
that
Odisha
is
High Court.
Odisha, yes. Thabir Sagar versus State of Orissa. In C, in Thabir Sagar versus State of Orissa, the Honorable High Court of Orissa, while delivering the judgment in a bail application number 748 of 2021, this is what paragraph you showed?
This is minutes paragraph 10 stated, only paragraph 10 maybe. No, this is Allahabad. Odisha High Court.
3, I think. 6, I think.
6, 7. And,
While, in so and so, the Honorable High Court, while delivering the judgment in bail application number so and so had held.
Para 14 conclusions are summarized, para 14 may be referred.
Had
In
held
that para, sub-para 3.
had held here to or advocate is also written.
In fact, minutes para 14.
14.3 you see.
Yes.
An affidavit may be presented either by the petitioner or the declarant or the pyroker or advocate or such person as duly appointed in writing only.
Subject to the previous conditions
Minutes, in fact,
that are contained in paragraph.
para 6 and 7 maybe. Because minutes, this is with regard to the advocate's clerk's affidavit reference. Therefore, this is.
Okay. He will go into paragraph 6 you said.
Subject to Odisha High Court rules.
Wherein the Honorable Orissa High Court held that
These conclusions are only in reading of the above mentioned rules.
Yes.
Para 14 is not relevant to general principles.
this is actually on advocate's clerk.
Yes, minutes. In fact, and this is also subject to the Odisha High Court rules. So there may be some gap in the observations vis-a-vis rules. Because this is in the light of the CPC Order 13 and the Odisha High Court rules. On the same lines, my submission is that this also lays the same situation. What applies to an advocate's clerk is with more rigors of section 30 of the Advocates Act applies to the lawyer.
But then still it is on that advocate's clerk line. Of course,
Yes.
Order 19 says so, but that is different. Where the Honorable High Court held that in view of Order 19, Order 19 of the Code of Civil Procedure,
Para 6.
read with Chapter 6 of the Orissa High Court rules, the affidavits has to be filed in the proper form. Then
Then Delhi High Court.
Delhi High Court, number D, Anil Kumar versus Amit. Anil Kumar and another versus Amit. In Anil Kumar and another versus Amit, the Honorable Delhi High Court, while delivering a decision in CRP 75 of 20 and CM Appeal 29470 of 2020 had held
Para 7, let's, with reference to Baker
yes.
Oil Tools.
That the advocates should not play a dual role, that is, act as an attorney holder and verify pleadings and file applications. The advocate should not play a dual role, right? That is what I said. Should not play a dual role, that is, act as a attorney holder as well as file applications or other documents, act as an attorney holder as well as verify pleadings and file applications and other documents, or give evidence on behalf of his client. Full stop. By referring to the by referring to the aforesaid judgments, Mr. Naresh Kaushik submits that in the present application, the advocate who is authorized, the advocate who has sworn the affidavit No, change it. He submits that the person who has been authorized by the accused person
Let's,
and who has
Lordship
also
may
sworn the
rephrase it in
affidavit.
this manner, that the affidavit is invalid, that being of an advocate of the petitioner.
That way you can write.
Yes.
Submits
And
that.
therefore the petition is defective.
Submits that the advocate, that the advocate who is appearing in the matter, who is appearing in the instant case, has filed the affidavit on behalf of his client, on being authorized by him, by the client, to do the needful. The advocate who is appearing on behalf of the accused person, having sworn the affidavit, makes the present petition invalid, since he cannot step into the shoes of the client and file the affidavit and appear before the court to defend the accused person. Mr. Jordan so and so appearing for the petitioner prays for some time to get instructions to look into the matter and get instruction in view of the instant issue raised by Mr. Naresh Kaushik, learned counsel. Prayer is allowed. Let the matter come up along with the other matters which are fixed on
24th.
Let the matter come up on 24th. List the matter on 24th of June 2025.
My lords, we have it on 23rd. 24th I have something.
List the matter on 23rd.
Wait for
23rd of June. Is it okay for you?
Could it be 25th, 24th or 25th?
It's up to both of you, whatever convenient
25th?
date.
My lords, we may separately, we may decide on a mutual date.
Okay,
We'll
then let
inform
us
the
know.
court master.
Okay.
It is either 23rd or 25th, whichever.
Okay.
Great.
Keep the judgments inside. Hey, this remained for the other one. Just see. I think it is related to 15 of 24. I think it's in the same first case. Show me, I will see. Oh, this is here only. This is a judgment. Do both the matters. 2 and 4 both.
Item 3.
Your Lordship, this matter is for the release of the petitioner's motor vehicle. And Your
Oh,
Lordship,
yes, yes,
the
that,
last day, we
You have
had
filed
a-
your affidavit?
Yes, we have filed our affidavit, Your Lordship.
You're
And
there.
As per Your Lordship's order, we have supplied the affidavit incorporating the charge sheet.
It's a big affidavit.
And regarding the insurance, Your Lordship, on that day, on the last court day itself, the counsel for the petitioner submitted the application to the Excise and Narcotics Department officer in charge, which your lordship will find at page 51 of the affidavit. And we, at page 51, application was submitted for the copy.
51 is a part of the case diary.
No, 51, your lordship, 51.
Huh. But the additional affidavit for submission of additional documents.
Yes. So your lordship has directed us to submit the charge sheet, copy of the charge sheet, to the insurance
Yes.
copy.
In
So
order to
one-
fix the bond.
Yes, one we have submitted the charge sheet, and regarding two, since the insurance copy has been seized along with the vehicle, we have submitted an application for a copy to the officer in charge of the Excise and Narcotics Department, lordship. And on that day itself, the officer in charge went through the records of their copies, their records, and they have not found the insurance copy. So that on 52, he has written a certificate, the officer in charge, page 52, your lordship.
I don't know, 52 is your petition, your
Yes,
application.
yes, petition.
As
And
directed by
53
so-and-so, I am applying for issuance of an insurance policy. Okay, what is his reply?
On the next
Certified
page,
that is not available.
Not available.
If it is not seized and available, it must be with you.
No, it was in the car itself, your lordship. So we don't keep the insurance because whenever traffic police stops us, we have to produce the insurance. It
this
has to be
is-
the car. So it might have been misplaced, your lordship. So anyway, your lordship, and your lordship has also verbally instructed us to find out the value of the second-hand vehicle which we have transferred for the barter system of the car, your lordship.
So that you have reflected in the
Yes,
affidavit.
at paragraph 4 of the affidavit, we have reflected that.
Paragraph 4.
Yes, it was an old vehicle, and he has says that he has previously met an accident. So maybe around 2 lakhs was the vehicle, the second-hand vehicle, which he himself has also bought as a second-hand vehicle.
Acha.
So that was the only issue left, your lordship, because the matter was dealt at hand by your lordship.
So 8 lakhs in consideration and also transferred ownership of my second-hand vehicle, which is 2 lakh.
Around about 2 lakhs.
So all total 10 lakhs.
Yes, your lordship.
Right.
And your lordship will make one prayer, your lordship, is that if the bond will not be too excessive, your lordship.
No, first of all, let me decide whether I'll give you the vehicle or not. Acha. So what you have said is that he is the owner,
Yes,
the petitioner is the owner being the father and the subsequent purchaser of the
yes.
vehicle.
And the first owner, which has given
An
affidavit,
affidavit.
that he has signed and that no.
Sell letter and the affidavit are the two documents showing that he is the owner.
Yes.
That's okay. So what you have to say?
Yes, Your Lordship. Your Lordship, what I have to mention is that previously the appellant has approached the trial court.
Yes.
And in that trial court, my lord, it was objected on the grounds that the owner of the vehicle cannot be ascertained
Last time I
regarding
remember
the
saying.
documents which the appellant had provided. And the judgment and order is in page number 43 of the application, of the main application.
43.
43, the last paragraph.
Yes. Huh.
If I may, Your Lordship.
43? No, no.
43,
43 is different.
This is different.
That is
Your
order of
lordship, the order will be in the beginning of the review petition itself. Revision itself, right after the index.
yes, sorry, Your Lordship. It's in D.
Yes, I've got it. This is
In the last paragraph.
the
There
sale
is-
letter has no witness and is not registered.
Yes, Your Lordship. So it held, the learned trial court held that this is doubtful. So even in this new application, my lord, there is nothing which the applicant had provided to ascertain that he is the rightful owner. And my lord, as per the Zima application, nothing is there, nothing is mentioning about the rightful owner except the affidavit which they have filed.
Where are
And-
the pleadings that where you have stated he is the rightful owner?
Except the sale
My
deed,
lord,
nothing is
we
there.
have, like, she has countered herself again. She admitted that the forest owner has submitted an affidavit before this honorable court saying that I've sold the vehicle. I've sold the vehicle. I have no more claim on it. And so what more can be the
No,
this being
where are those pleadings apart from
Yes,
affidavit
Your
and?
Lordship. At para 2 of my pleadings, Your Lordship, at page 2. If I may kindly take Your Lordship there. That on 15/5/2023, the petition, have Your Lordship got it?
Yes, yes, I've got it. But then in that paragraph you have said yes, you have purchased, but then you are the rightful owner. That sentence is not there.
Yes, my lord,
He
no.
is also arrested and not in-
In this
Oh,
connection,
you have there, you have written in paragraph 4,
yes, Your Lordship.
on the ground that, no, this is what the, yes. Did the order speaks of, on the ground that alleged contraband was carried in the vehicle and that he is the rightful
My
owner.
lord, we have, starting from para 1, we have stated that the petitioner is applying for the release of his vehicle, which he has bought and so, and we have stated, we have pleaded that we have bought the vehicle by paying so and so amount, and along with that, and the previous owner had made an affidavit.
In paragraph 5, I think you have written it.
Yes, my lord. The petitioner is the rightful owner of the seized vehicles, also we have written, Your Lordship.
So that is your only ground that he is not the rightful owner, right?
Yes, my
And?
lord. And moreover, my lord, the seized vehicle is of crucial evidence in the present case, and now it is on trial, and releasing at this stage may comprise the trial, my lord. And there is a risk of tampering the vehicle, altered and disposed of.
No, I
During
think
the
the police
pendency
have
of the
stated
trial.
that they do not require for any further investigation, I think.
Yes, my lord. Charge sheet has been filed, Your Lordship.
Huh. And
And-
moreover,
Yes.
I think the learned trial court had called for a report. There was no report called for by the lower court. The-
No, my lord. It's not there.
As stated.
Oh,
under
in
the-
the IO has already submitted in the charge sheet.
Yes,
The trial has commenced and as such the vehicle is no longer required. Where is that sentence in the charge sheet? That they do not require, because even after charge sheet they can give some supplementary thing.
No such thing is written in the charge sheet, my lord.
Acha.
it's been
But then
almost
it's
2 years.
it is written by the trial court itself. Just see the charge sheet if the statement is there. Where is the charge sheet, Mr. Hari?
It's annexed to the affidavit. Your Lordship.
See, just take out that line from the charge sheet. That no longer required.
My lord, the seized articles, the contraband, which have been separated from the vehicle.
that
and
has
they
been
have
taken out.
sent to the, so the vehicle has been kept in the police custody almost 2 years now, Your Lordship. Charge sheet has been filed, and as the judgment of the court, which we have provided earlier, the Supreme Court has said that a bond can be given, conditions can be given by the court for a requisition of the vehicle if needed by the court. So, but keeping there pending trial, which will most probably take another 3-4 years, there's no use. That's what Your Lordship. I'll just take it that judgment, Your Lordship, which we have earlier provided, Your Lordship. My lord, the recent judgment, I'll start with the recent judgment. It's 2025 3 SCC 241, Biswajit Date versus State of Assam. This is coming from the Assam High Court only, guys.
2025?
3 SCC 241. Biswajit Day versus State of Assam. And this is a vehicle which was seized in connection with an NDPA case only. So it's squarely covered by this judgment.
No, as far as giving it back to you is no difficulty. Only problem is whether you are the rightful owner. That is what the contention is.
On that contention, my lord, I have also...
Only sale letter and the affidavit and your pleadings. What I'll do is let the vehicle be given to him and the police will further verify the ownership
Yes, Your
or
Lordship.
the magistrate court. Now that his trial is going on.
Oh, my lord, that will just put more... There won't be any use of this revision, Your Lordship. Your Lordship, as we have submitted earlier, whenever we buy a new vehicle, let's suppose, I go to the dealership, I buy a new vehicle. So it is covered by the Sales of Goods Act.
And that you have
And
shown last
we
time.
do not need to, the only reason the trial court has denied us is that it was not printed on a non-judicial stamp, it has no witnesses. Those are the two only, non-judicial stamp and no witness. Whenever a person buys a new car, supposing, the sale letter is not made on the non-judicial stamp. There is no need of a witness to buy a new car. I can give my money and they can give me the car. Why is it different for a second-hand vehicle? It is not different at all, Your Lordship. So those requirements which the trial court has said are not required for a sale to be valid, a movable property to be valid, sale of movable property to be valid. It will be required in the case of an immovable property. And another point is that, Your Lordship, the re-registration is after post-event. We have stated that in the Supreme Court judgment. If Your Lordship will need, we can refresh on that. So, my Lord, if we go to the Sales of Goods Act, under which transactions of movable properties are covered. Section 4 says when the seller agrees to sell the thing, any property, and the buyer give the money, then the sale is complete. So the affidavit, there is no dispute, Your Lordship, by the respondents that Kapil Ahmed is the first owner. There's no dispute on that.
Yes.
And they have also, if that is not a dispute, Your Lordship, that Kapil Ahmed have made an affidavit stating that I have sold it so and so. Even if the sale letter, if the Lordship will not consider the sale letter, at least consider the affidavit that he will have no more claim on it. I have sold it, I have transferred it, and there is no objection regarding the ownership, the first owner, that is Kapil Ahmed. So there can be no more documents to show, Your Lordship, that this vehicle, the ownership has passed.
Okay, I'll give the order. Listen to it. Okay.
Yes, my lord.
What do you have to say?
Only one submission, my lord. Whether the vehicle is released on Zima or not, that's up to the court.
What?
So, my lord,
what did you say?
my submission is that if the vehicle is released, there might be some stringent condition which has
Conditions
to be
too I'll
enforced.
put.
Yes.
All bond he has to place, and I'll also give a further direction to police, the magistrate to see, if required, if they are not satisfied with the owner, if required. I'll say about the sell letter affidavit. Just listen to the order. Wherever you have something to say, point out. Just write it then.
My Lord, if the judgment which I have placed before Your Lordship, if they may be, that may be...
I'm dictating, so you can say. Okay, so I must have written it somewhere, the judgments that you have placed.
Because in the last
Okay.
one we have dealt at length.
You are there, you just point me out then. Okay, this is a instant petition. Instant petition, being criminal revision petition number 5 of 2025. You can sit and no need to. Is filed for setting aside, right? What is your prayer? Is filed for setting aside the order dated 25/4/2025, passed by the learned judge, Special Court, ND and PS Act, Aizawl, in criminal miscellaneous application number 31 of 2025, arising out of excise and narcotics case number N209 of 2023, by which the learned court mentioned above by which the learned court mentioned above did not allow the interim custody of the vehicle seized in connection of the said case to the petitioner. Interim custody of the vehicle, I said, no? Vehicle which Mahindra Thar, that is, or which Mahindra Thar, red color, within bracket, red color, B/R, number AS12 AD 9507. To the petitioner, right? To the petitioner, the interim custody of the vehicle, namely so and so, was not allowed to the petitioner on the ground that the petitioner could not substantially place documents showing his ownership to the said vehicle. Full stop. In the instant petition, the petitioner had further prayed for interim custody of the vehicle to the petitioner concerned, pending trial. The factual matrix the factual matrix of the instant case is that, on 27 July 2023, the personnels of Excise and Narcotic Department, Mizoram, Aizawl, on a secret information from a reliable source, about transportation of some quantities of contrabands by using a Thar jeep, by using Kokkato, transportation of some quantities of contraband, stopped near a custom check a Thar jeep, a suspected Thar jeep, and in presence of witnesses, they conducted search in that jeep, and subsequently found a yellow nylon bag, and inside there was 55 number of soap box containing suspected heroin. The police personnel during the search took out the drugs, weighed it, and found the same to be 653 grams of suspected heroin. The police as such, the police thereafter seized the Thar jeep which was used for transporting the said heroin. The seizure, no, wait, no. Then, thereafter the police personnel conducted the required exercises under the NDPS Act. Para. In this petition, what this learned court is concerned with is the seizure of the jeep and the subsequent custody to be given to the owner concerned. The petitioner moved an application. Before that, the police personnel, on completion of the investigation of the entire case, submitted charge sheet on 30/12/2023. Then the petitioner on the petitioner filed an application before the Special Court NDPS Aizawl Judicial District, Aizawl, Mizoram, for interim custody of the said vehicle, that is Mahindra Thar, which was seized in connection with the aforementioned case. However, the learned court was pleased to refuse the interim custody of the vehicle to the petitioner as mentioned above. Assailing this order, the instant revision petition is filed. Mr. What is your name? Mr.
Jonathan L. Silo.
Mr. Jonathan L. Silo, appearing for the petitioner, submits that it is he submits that it is no res integra. Submits that it has been held by the Honorable Supreme Court in a number of decisions that the seized vehicles should not be kept in the police station for long, as the same would get destroyed with time, and the same may be given in custody to the rightful owner by the authorities concerned, pending trial. He had also submitted that the petitioner is the rightful owner of the vehicle, which is established by the sale letter as well as the affidavit that he has annexed with the instant petition. He submits that the petitioner has bought the vehicle from the erstwhile owner, Mr. Kabil Ahmed, on 15/5/2023 by executing a sale letter on the same date, which is annexed as Annexure 1 to the petition. He has also placed the affidavit dated 15/5/23, sworn in between both the erstwhile owner and the petitioner. No, affidavit is not dated 15/5. Cut the date. Sworn in, last sworn in by the parties concerned on. No, what did I write? Last sentence. He has also placed the affidavit. No, dated you cut. Also placed. Petitioner that the vehicle has been sold to the petitioner concerned. You write that date sworn in on 28 April 2025. Full stop. As such, he submits that there is no impediment in handing over the vehicle in interim custody to the petitioner concerned pending the trial. He has placed few decisions to substantiate his point. No, before the decisions you write, he placed section so and so of the Sale of Goods Act. Give me that Sale of Goods Act. He placed section what? 30.
No, Lordship. 4, 5, 19 and 20. Section 4, Section 5, Section 19 and Section 20.
That day I think you placed one specific section.
That is 19 and 20.
19.
19 and 20, Your Lordship, because 19 and 20 are connected.
He placed section 19 and 20 of the Sale of Goods Act to substantiate his point. Section 19 and 20 is reproduced below. Section 1920, you write it from here, the book.
My Lord, on
He further states that since in the instant case the article involved is a movable property, the property passes to the buyer when the contract is made it's okay, moves to the buyer as soon as the contract is made. In the instant case, he submitted that the article involved is a jeep and the agreement is entered into between the parties for the sale thereof, and as such, the ownership has passed on to the petitioner concerned. He further places reliance on the following judgments. And what were those judgments?
2024 SCC online SC 519.
This one I have. Yes, first you write the name of the parties. Karikho Kri, Karikho Kri, Karikho, Kri, Kri versus Nune, Nuney, Tayang, Tayang, and another, reported in 2024 SSC online, SC 519. Paragraph
23, paragraph 23 and 27. 23, my lord, you can start from the middle of the page. Can start from further, if your lordship have got it.
Yes.
Further, the vehicles being good.
Yes, yes. I said he placed the decisions. What did I say? No, before that. Decisions. Then you give one. In so and so. In so and so. Reported in so and so. The Honorable Supreme Court had held in paragraph 23 that vehicles being goods, their sale would be covered by the provisions of Sale of Goods Act 1930, which makes it clear that conveyance of ownership of vehicle would stand concluded upon execution of document of sale oblique transfer and registration of the new owner of the vehicles concerned and registration of the new owner by the authorities concerned would be a post-sale event. This is on
Para 27, your lordship.
27.
Yes.
Further, the Honorable Supreme Court has held in paragraph 27 of the said judgment that mere failure to get registered the name of the new owner of an already registered vehicle does not mean that the sale oblique gift transaction would stand invalidated, and such a vehicle, despite being physically handed over to the new owner, cannot by any stretch of imagination be treated as still being in possession and control of the former owner. Stop. He also placed reliance on the judgment of this Biswajit.
Yes, your lordship.
He also,
Para 38, your lordship.
he also placed reliance on judgment delivered by the Honorable Supreme Court in Bishwajit Day versus State of Assam, reported in 2025, 3 SCC 241. This is on which paragraph? This is on giving of vehicles.
38, yeah. Yes.
Okay. as well as another Ambala also you are relying,
Yes, yes, Your
as well
Lordship.
as the judgment delivered by the Honorable Supreme Court in Ambala, Sundarbhai Ambala.
Para 17.
Report Sundarbhai Ambala, what was the name?
Sundarbhai Ambala Desai versus State of Gujarat.
Sundarbhai Ambala Desai versus State of Gujarat, reported in 2002-10.
Yes, Your Lordship.
2002-10 SCC
283.
283. These are your arguments?
Yes, Your Lordship.
On the other hand, on the other hand, you are the additional PP.
Yes, Your Lordship.
Your name I again.
Vane Siami.
Uh-huh.
Vane Siami.
The sheet is not, oh here it's there. Oh, here I think here it's pasted. Oh yes, yes. Van He Siami, Mrs. Vane Siami, Additional Public Prosecutor for the State of Mizoram, submits that as held by the learned trial court, that ownership is not properly, that the ownership of the vehicle not as you write submits that the findings of the learned, the Special Court NDPS Act, that the ownership is not properly proved is correct. She also submits that the sale letter which was annexed by the petitioner in his petition has no witnesses and was not registered, and the same was not on non-judicial stamp paper. As such, full stop, as such she submits that the owner is not ascertained and the vehicle cannot be given in custody to the petitioner concerned. That is all. Para. I have given this court have given anxious consideration to the arguments made by all the counsels and have gone through the records of the case. It is no res integra that the article seized in connection. Can you give me that Ambala case? Do you have? With any offence should not be kept in police station or malkhana for long. Since the same would result in destruction of the articles with time. As far as vehicles seized in connection with NDPS cases are concerned, there are provisions in the NDPS Act of 1985 for confiscation of the same. The relevant provision, the NDPS, give me that NDPS, provision is section 60, thank you, as well as 63 of the Act. full stop. Section 60 subsection 3. Cut that. Under subsection 3 of section 60, under subsection 3 of section 60, comma, it is provided that any conveyance used in carrying the narcotic drugs or psychotropic substance are liable for confiscation unless the owner of the conveyance proves that it was used without the knowledge of the owner himself or his agent, if any, and that each of them had taken all reasonable precautions against such use. Full stop. Under section 63 of the NDPS Act, it is provided, what? Now it is 1 almost, no? The rest I'll dictate it at 2? Or in between, if I get some time, I'll dictate it there also. Okay. I couldn't dictate in the chamber. I'll start again now.
Yes, yes.
I couldn't get time. Okay. Then what did I last write? Oh, okay. It is provided that the court shall decide whether any article or thing seized under the Act is liable to confiscation under section 60, section 61 or 62. Only after only after deciding as to whether the accused is to be convicted, acquitted or discharged. Further, in the proviso under section 63, it is provided that no order of confiscation of any article shall be made until the expiry of 1 month from the date of seizure, or without hearing any person who may claim any right thereto, and the evidence, if any, which he produces in respect of the claim. A conjoint reading of section 60 and 63 makes it abundantly clear that the confiscation of the vehicle used in carrying the contrabands can be only after the conclusion of the trial. It also makes it clear that pre-trial disposal of conveyance is possible only if no one claims possession or custody of the same. Para. It is also seen that in the NDPS Act 1985, there is no provision for allowing interim custody of the vehicle concerned. I think there is a provision in NDPS that CRPC will be applicable, right? Yes. What is that? 36 Nikinike? There is 36C, right? No provision, right? Huh. In that case, Section 36C of the NDPS Act 1985 would come into operation, which provides that provisions of CRPC 1973 would be applicable in certain circumstances. I've got it. CRPC. Section 451, right? 351. Section 451 of the CRPC provides for custody and disposal of property pending trial in certain cases. Section 451 is reproduced below. Section 451 quote कर देना. Applying the aforesaid provision in the case at hand, there is no bar in giving the vehicle used in carrying the contrabands in interim custody to the owner concerned. Supreme Court in a number of decisions has held that the vehicles has to be given to the rightful owner pending trial, so that articles बोला है vehicle लिखो, it's okay, vehicle pending trial, what did I say? The vehicle does not get destroyed being kept in the police station for long. In Sundarbhai Ambalal Desai versus State of Gujarat, Supra, I have mentioned it before, so within bracket Supra, it is held in paragraph 18 17, paragraph 17, that whatever be the situation, it is of no use to keep such seized vehicles at the police stations for a long period. It is for the magistrate to pass appropriate orders immediately by taking appropriate bond and guarantee as well as security for return of the said vehicles if required at any point of time. The Supreme Court also held in the said decision that in any case, before handing over possession of such vehicles, appropriate photographs of the said vehicle should be taken and detailed panchnama should be prepared. In Biswajit also that same thing is stated, right? In Biswajit decision. Which paragraph? Biswajit? Huh? 38. In Biswajit, Day versus State of Assam, Supra, the Honorable Supreme Court had categorically stated that if vehicle is allowed to be kept in the custody of police till the trial is over, it will serve no purpose. The vehicles in police custody are stored in open, amenable to destruction. Full stop. The Supreme Court, the Honorable Supreme Court had further held that if the vehicle is not released during the trial, it will be wasted and suffering the vagaries of the weather, its value will diminish. In the instant case, it is seen that the petitioner bought the vehicle from the erstwhile owner, Muhammad Kabil Ahmed, on 15/5/2023. And the offense in connection with which the said vehicle was seized happened on 28/7, no? When was the article seized? On
28/7/2023.
The offense happened on 28/7/2023. That is after 2 months of the purchase. After around 2 months of the purchase. Although the sale letter was executed on the date of purchase itself, that is on 15/5/2023, and the affidavit was executed on 27 kuch tha na? Affidavit was executed on 28/4, na? No, not 24. Affidavit was executed when?
28/4/2025.
Quite late, no?
Yes, ma'am. It was just to make sure that the sale deed has been not a forgery or that. And I love since the seizure, it has been 690 days or 1 year, 10 months, 20 days.
Yeah, I'll mention that. Okay. Yeah, what did I say? As the sell letter, okay? No, not the affidavit, Choro. You cut that. 2 months after this 2 months thing, write again. Okay. It is seen, therefore it is seen that the period is very less from the date of sale of the vehicle to the petitioner and the date of seizure of the vehicle in connection with the offence in connection with the offence concerned. And it can safely be held that registration in the name of the petitioner could not be done in the meantime. The affidavit which was executed between the petitioner and the erstwhile owner on 28/4/2025 also establishes the fact that the petitioner is the owner of the vehicle in question. It is also held by the Honorable Supreme Court in Ambalal Desai case. Sundarbhai Ambala Desai, Supra, that vehicle can also be given in custody to a third person or from the person or to the person from whom the vehicle was seized or to the insurance company. This finding makes it abundantly clear that the vehicle should not be kept in the police station or elsewhere for long, and it should be given to any of the parties mentioned above. And if nobody claims, then the vehicle is ordered to be auctioned by the court. So in any circumstance, the vehicle should not be kept in open as held by the Honorable Supreme Court.
If your lordship requires, just calculated the days of how long it has been under the police station.
Yes, that is
Yes.
also required.
It has been 1 year, 10 months, 20 days, or 690 days.
1 year, 10 months, 20 days. It is seen in the instant case that a vehicle is kept, it's in the police station. It's where? Do you have any information?
Excise and narcotics
Uh-huh.
custody.
It is kept by the authorities concerned in open for 1 year, 10 months, 20 days as of today. The same is not called for in view of the law laid down by the Honorable Supreme Court. Para. Hence, this petition is allowed. And the authorities concerned are directed to release the vehicle, that is Mahindra Thar, bearing registration number registration number, this is what, registration number is there only, registration number AS12 AD-9507. To the petitioner, subject to the following conditions. 1. The petitioner shall furnish bank guarantee of rupees, so it comes to around 10 lakhs.
10 lakhs.
So, 5-7 lakhs or what? The
50,000
total value is 10 lakhs.
Total value is
Huh.
10 lakhs, and my lord, if it's possible, half of the
Half,
total
five-
value,
5
5
lakhs?
lakhs.
3 lakhs, Your Lordship. My lord,
Second hand vehicle, 10
second-
lakhs.
Yes, my lord. And we will give the guarantee, and Your Lordship can order that it will be produced when.
That too I'll have to, I'll say.
So,
Okay, petitioner shall furnish a bank guarantee of rupees 3 lakhs before the honorable court. 2. The petitioner shall produce the seized vehicle before the trial court as and when called for during the trial, and also during the confiscation proceedings if any such proceeding is initiated. 3. The petitioner shall not alienate the seized vehicle or change its nature and character during the pendency of the case. 4. The seized vehicle shall not be used for any offence. 5. The vehicle before its release should be properly photographed, and photograph will be made part of the record. Engine number,
my lord, those are already there in the charge sheet. The photographs and the engine number.
no,
everything.
but then still again, because even Ambala says taking photographs and all, that is different for seizure purpose.
And, my lord, if that is the case, it's in the custody of the excise. They should allow us to take the photograph, or they themselves are going to submit it. That's the
No,
question.
they will take the photographs. Chassis, engine number and chassis number of the vehicle should also be noted for future reference. And I think in this one case, which one? Biswajit Day.
If Your Lordship, in that order, if the excise department are directed to do that, taking of photographs, like in the written, that the Excise and Narcotics Department should take the photograph, keep the photograph.
Okay, authority concerned, I'll
Yes,
take.
yes.
Okay. There was one more condition, I think, which was stated in Biswajit, right? Which shall be authenticated. Photographs have written and chassis number and then 6, the authority concerned should also prepare necessary documents for identification of the vehicle, which shall be authenticated by the investigating officer, comma, owner of the vehicle, by signing the same. This is where it is in Biswajit.
Yes,
And one more, condition 7, so many. The appellant shall not, the petitioner shall not sell or part with the ownership of the vehicle. This is actually changing the nature, but then
yes,
still,
it
this,
already written alienated.
so alienated, right?
Yeah, so
So this will not be required, I think. Okay, this is not required. Alienate is there. Full stop. The impugn, then the impugn order dated
25/4/2025.
the impugn 25/4, 25/4, right? This, the impugn order dated 25/4/2025, passed by the Special Court NDPS Act, Aizawl Judicial District, in criminal miscase number 31 of 2025 is accordingly modified. Full stop. The petition is disposed of.
Obliged, Your Lordship.
Anything else? No, no? It's
No.
enough. You want the
Will be obliged.
judgments back?
Yes, madam. If-
It can use it for other cases. Oh, no, no, there are more. Yeah, sure.
Item 5.
Item 5. Part 1 is also not over till now. I think respond number 11 is not served, right?
We have already taken another fresh step,
Huh.
Your Lordship, and I don't know if the notice has returned.
No. Yeah, yes, on the last occasion 26/5 steps were taken, right? And it was awaited. Fresh steps. But in the office note it is written that not returned back from respond number 11. Let us await for some more time because fresh steps were taken 16/6. Right?
Yes, madam.
No, no. Fresh steps were taken, I think 26/5. Report is of 16/6.
Yes, madam.
25/4. No, no. After this again fresh. 26/5. But then this is only the report.
You know, the council was here, Mr. S.K. Mehdi was here, but I don't know if he has gone.
Mr. S.K. Mehdi from Guwahati.
Yes, he was here in the morning, Your Lordship.
Acha.
I don't know if he is.
And afternoon of, oh yes, S.K. Mehdi, I know him. R.K. Dev Chaudhary. No, they are for respondent number 4 to 6 only and 9.
Yes, madam. 4 to 6, 9, Your Lordship, 9, 11 has replaced 9. Because 9 has retired and the new incumbent is 11.
Acha, acha.
So actually, for 9, this Mr. R.K. Dev Chaudhary has already submitted an affidavit.
They are not here today.
But they are not here today, Your Lordship. Anyway, Your Lordship, we can wait one more.
We will await. Otherwise, it is not shown that he has filed Wakalat Nama for 11.
Yes, madam.
25, this is 26/5 again, see? Submitted fresh steps have been taken. Acha sir, this is the fresh steps. Oh, have been taken and ID card is awaited. Oh, acha, last time only. Okay, then we will await for some more time. Or what? Expert day. Okay. So 3 months is not over, I can say. Okay. Heard Mr. Jonathan S. Silo, L. Silo for the petitioners. This is a contempt petition.
Yes, Madam.
For the petitioners. None appears for respondent, private respondents. Private respondents? Yes, yes. None appears for the respondents. Number 4 to 6. What about 7 and 8?
One second, Your Lordship.
7 and 8 perhaps
My Lord, there has
replaced.
been lots of replacement. 7, my Lord, was replaced by 10.
Acha.
And thereafter, 8 is there. And
I
9 has been replaced by 11.
Okay, we will await for service only in respect of 11.
Yes.
Okay, none appears for the respondents. It is further seen that on the last occasion, it is further stated by Mr. Jonathan L. Silo that he had taken fresh steps for service of notice upon respondent number 11. And the office note dated 16/6/2025 shows that neither the AD card nor unserved notice has returned back in respect of respondent number 11 till date. Await further. A service on respondent number 11 may be awaited further. List the matter after a week or 2 weeks after a week. List the matter after a week on a date fixed by the registry.
Obliged.
For orders, item 6.
Oh, that I have to know. Just a minute, right? What has not returned back, I said, no? It is as such directed that the registry of this honorable court may track, what do you say for that? May track the postal consignment as regards the service of notice upon respondent number 11. Await cut it, list the matter after a week on a date fixed by the registry. This is a bail application.
Yes, may I please, Your Lordship, this is a bail application under section 483 BNSS, read with section 37 of the
NDPS Act.
NDPS Act, yes.
The trial is on.
The trial is on, yes.
So we'll have to call for a scan copy.
No need to, we have annex here that whole charge
You
sheet.
have annexed, but
Yes.
then we have to see what is stated by the witnesses so far. So let the scan copy be called for.
Yes,
That is the normal procedure actually.
yes, my lord.
So let the scan copy come. Then we can see what they have stated on the basis of that bail.
Yes, my lord.
This is an application for bail under section 483 of the BNSS, read with section 37 of the NDPS Act, for granting bail to the petitioner in connection with
5 upon PS case number,
in connection with
Session registration number 185 of
Sessions
2020.
registration number, no, in connection with what is the police case number?
Viva Code, police case number 410.
410 of 22,
Yes.
registered under section 21C, read with section 28, 29 of the NDPS Act, 1985. It is seen from the records, it is seen from the petition that a charge sheet is submitted and the trial is on and witnesses are also examined. Full stop, para. Call for the scan copy of the sessions case number. Trial is on White
Yes.
sessions case number, you write. White sessions registration number 185 of 23. Okay. Then you write, let the scan, call for the scan copy in connection with sessions registration number 185 of 2023 from the court of
Special Judge NDMPS Act is all.
a special judge, NDPS Act, Aizol.
Yes.
Special
Miss Mary, this, I didn't ask you. This is
Yes.
what is done, has to be
Yes,
done.
yes.
Let the
Your
scan
Lordship-
copy come.
Your Lordship, it's a special court, NDNPS Act.
A special court, NDPS court,
NDNPS Act.
Act, something again, some Aizol, Mizoram.
Aizol,
Aizol.
Judicial District Aizol.
Judicial District Aizol. Matter may be, list the matter after 2 weeks. How long does it take for the things to come? 2 weeks is enough, I think.
No,
Or
even,
for 3
even
weeks.
1 week will suffice.
1 week,
Your
my lord.
Lordship.
Okay, 1 week.
Yes.
List the matter after 1 week.
Oblige, Your Lordship.
Item 7.
Bail
Lordship,
application
yes,
again?
this is also a bail application, Lordship, but this one is non-charge sheeted, Lordship.
Or this one is not charged?
Yes, non-charge sheet.
So, case diary?
Case diary may not be required, Your Lordship, since I have annexed relevant documents, Your
But then no
Lordship.
case diary we'll have to see.
Lordship, the petitioner was arrested solely on the ground that there was an WhatsApp messages between the main accused and the petitioner himself, Your Lordship. And
No,
there is a
but then-
clear violation of section 47 and 48 of the BNSS 2023, Your Lordship. So there are several orders passed by this honorable court regarding that,
No, but
Lordship.
then again, we have to consider the case diary and give the bail order. This is what is the practice.
Lordship,
What the witnesses had stated before, the police will have to see those.
Lordship, I have annexed most of the
You have
relevant
annexed that, I
documents.
know, and there is nothing to disbelieve, but then let the case diary come and we will consider.
Lordship, yes.
Over, Miss, yes?
Yes,
Let the
Lord.
case, bring the case diary, then only we can.
Yes, my lord, if case diary may be called.
Yes. Normally what we do is, if it is an AB,
I understand,
then we
Lordship,
can give
yes.
interim and call for the case diary. This is BA, he's already inside. So case diary, on perusal of that, we can give regular bail, so that is.
And also the petitioner is without any involvement. He has been in 66 days in the jail. So I think that the
90
matters
days is
may-
the,
yes, but 90 days, but 66 days without any involvement. Only the WhatsApp messages, Lordship.
this is NDPS, right?
NDNPS, Lordship. And
If
there is a
people
clear
are
violation
inside
of.
for 3-4
Yeah.
years,
But Lordship, maybe in the other cases, maybe 3-4 years. But here in this case, in this particular case, his involvement is not, like established before the trial court, and even in the this arrest memo also, Lordship. So there are so many violations.
next week you can move, case diary will be
This-
here.
Next week, Monday, Lordship.
Monday, Tuesday, if she can bring, what is the district, what is the police station here?
Kozo
it
Police
far?
Station, Kozo Police Station.
Is it
And a
far?
scan copy can be given to us also.
Kozol
It's
police
not far.
station is out of station, so it might takes time,
1 week,
1 week, yeah.
1 week. Heard
And
Mr. Swansea.
Lordship, date may be fixed, Lordship.
Okay, I'll fix it. Heard Mr. Swansea for the petitioner. And Ms. Van Hen Shyami, right? Van Hen Shyami,
Van Hen Shyami.
additional public prosecutor for the state of Mizoram. Call for the case diary. List the matter on
24,
When?
24.
This is June.
Uh,
24.
and,
24 will be too early.
Today is 16 and not 6.
Holidays will. So? 26.
26.
17 along.
Acha. 26th? 26th June?
26.
Also, yes.
26th June 2025.
Sublime.
Oblige.
Hearing list, item number 1.
Item number 1. What is that? Okay. Just a minute, Mr. Malhotra. Okay. I think here you are supposed to bring the latest instruction of the SIT, right?
I have a copy of it, my lord.
Acha, acha. Then he has to go through or what? Have you given him the copy? No, na?
I can submit it by way of an affidavit, my lord, if your lord.
This will be better instead of seeing
Just
this
giving
way.
it on papers, my lord.
This is. Then you give him an affidavit only, incorporating that. What is the status? Otherwise, he has prayed for CBI investigation. I think.
At point number 6, my lord. Final progress report submitted to Supervising Officer DIG Northern Range on 10/6/2025, reporting completion of investigation with a request to approve submission of final report of investigation
Again
to
final
CJ.
report?
Yes, my lord.
Acha.
Then your worship, let them submit it to the court.
Then again, protest petition and everything will follow.
Otherwise, your
Earlier
worship,
also final.
yes. I mean, your worship, they have already submitted one final report. Now again this. That is why, your worship, we had come to this honorable court, because it's like appeal from Caesar to Caesar. They are bound on submitting a final report. Let them submit it to this honorable court, and the honorable court can see. Because, your worship, there are lots of points which have been raised by us. In fact, your worship, if I may take your worship, just to give an example to the final report.
Yeah.
The final report is at page 16.
16.
Yes, annexure 3.
Wait, there are so many petitions here. 16, yes.
Bottom of the page, your sorry, page 17. This is the page 16 is the final report. I'll take your lordship to page 17, the last paragraph. The IO held inquest over the dead body of deceased Ajit Kumar Rai at Mopa PS. As the dead body was brought at the PS by 39 Assam Rifle personnel of Ming Boom Post before police arrived at the PO. During inquest, the IO observed 2 wounds, one at the forehead and the other below right eye, suspected to be gunshot wounds. Some dust was also observed on the right knee, seems to occur due to kneeling on the bunker floor. On checking the dead body in prone position, 2 wounds were also observed on the nape.
Name. On the back side,
Yes.
name. Yes.
This has not been addressed by the police at all.
Because it was a gunshot by himself, suicide case, right? So nap injuries.
So,
not
so
at-
that is ante-mortem.
that is antemortem.
They have not mentioned anything in the post-mortem report also. Because the case of the police is that he shot himself, 2 bullet wounds. AK-47, it was in automatic mode. He pressed it once, 2 bullets entered his head and below the right eye. Then what about the injuries on his nape? Where did they come from? There is no investigation on that part.
So let them file an affidavit and then this honorable
And
court.
in the
will
meantime,
obviously-
your worship may kindly call for the records from the CJM Champai court, where because the FIR was submitted by the petitioner and FR final report was submitted before the Champai Chief Judicial Magistrate, and we had filed a protest petition. So the records may kindly be called for in the meantime.
What happened to that protest? Oh, again they had accepted.
The final report was there. Then we filed a protest. Then the Chief Judicial Magistrate directed for further investigation. SIT was formed. They submitted the SIT report, again asking for closure. Again, the CGM said, no, it's not enough. Further investigation. Now that further investigation has been carrying on for quite some time.
Yes.
And now again, they're intending to file a final report. But now, whether these injuries on the nape have been even investigated into by the SIT.
Those injuries may be of some earlier occasion, something might
Nothing-
have happened.
But, Your
then
Worship,
still there has
it
to be
is-
something.
It is in the inquest report. And inquest report,
No, those injuries may be old. for
but
some
nothing is
other-
mentioned,
but
nothing is mentioned. It is fresh on.
So, okay, let them file an affidavit stating this, and then the court will hear what can be done. First of all, let it be put on records. Heard Mr. A.R. Malhotra. Is that okay, Mr. Malhotra?
It's okay, Your Worship, the records may kind of, regarding,
No, those of protest petition and all those are there. What records you want?
no, Your Worship, in the protest petition, they have submitted in the police case, which is NOPA PS case number 28 of 2014, they had submitted a final report, and we had submitted a protest petition. And in that, the SIT had also submitted their report, and in that the FSL report is there, post-mortem report is, everything is there. And in
But
the,
those post-mortem report and all will be there in the case diary also.
let them produce that, because
Case diary has never been produced.
never been produced.
Oh. Case diary was never called for in this
Yes,
case?
it was not called for. So at least let them produce the case diary, where all the FSL report,
Everything.
and the PME report will also be there. Because in the inquest report, it is clearly mentioned about these injuries on the nape. In the post-mortem report, it is missing.
Okay. I'll
So,
call for the case
yes.
diary. I heard Mr. A.R. Malhotra appearing for the petitioners. Appearing for the petitioners in the instant petition, and Mr. Zairem Sangpui.
Yes, I am for respondent number 6, 7, 9, 10, 10 and 11.
All right, her name appearing for 6, 7, 9, 10 and 11. And Mr. You are
Samuel.
Additional Advocate General?
Yes, my lord.
Mr. So-and-so, Additional Advocate General of the State of Mizoram. Learned Additional Advocate General of State of Mizoram, Mr. So-and-so, has stated at the bar that in pursuance to the order passed on the last occasion, he has obtained the up-to-date report of the Special Investigating Team prepared in connection with NGOPA Gopa or Nopa Police Station, case number 28 of 2014, registered under section 302/120B IPC Red with 27(3) of the Arms Act. He as such prays that he may be allowed some time to file an affidavit bringing into record the said report of the Special Investigating Team. The prayer is allowed. There is also a prayer made by Mr. A.R. Malhotra that the case diary of the instant case, that is NOPA PS case number 28 of 2014, may also be called for in the instant case. As such, the learned public prosecutor, the prayer is allowed. You say the prayer is allowed. As such, the learned
Additionally,
you are additional public prosecutor?
No, my lord.
No. Who will bring? Some public prosecutor may be there. Additional public prosecutor who? Mary or what?
Mary.
Okay. Mary so-and-so is allowed 2 weeks' time to produce the charge sheet, to produce the
case
case
diary.
diary of the instant case. List the matter after 2 weeks.
Obliged, my lord.
This one you take it back and you file
Yes, my lord.
affidavit.
Item number 12.